I'm here today to bring a local government perspective. In local government, the application of the separation of powers is a little different than on the state and federal levels. It tends to have a more practical and daily effect on our lives. Outside of law school, my first significant exposure to the separation of powers was working as an attorney in state government. And the case of Brown v. LRC in 1984 was a must-reading case for any government attorney. And the Kentucky Supreme Court's treatment of the issues in that case and their language used in that opinion to make their points really opened my eyes to the majesty of the law and the issue of the separation of powers. The case was also a unanimous decision in a major separation of powers case, which is a pretty strong statement from any court, and it'd be doubtful that we would get such a unanimous decision in today's judicial bench. As the other speakers have commented, most separation of powers cases typically occur in the state and federal courts as you're dealing with constitutional interpretation of the state and federal constitutions. Local government's different. While we are certainly subject to the state and federal constitutions, our authority is mostly statutory and ordinal. In fact, KRS 67C 103 specifically sets forth the powers of the Metro Council, and KRS 67C .105 specifically sets forth the powers of the mayor and the executive branch. Today, since I represent local government in Louisville Metro, I'd like to spend a few moments describing some local examples of how the separation of powers has affected our local landscape. In 1947, in a case called Deerroof v. Jefferson County Board of Health and Leland Taylor Mayor, this case dealt with the excessive toll commission funds due to the numerous bridge crossings workers made in order to make munitions for the war. And the state legislature passed a statute that said that the mayor had the authority to spend the excess funding levels, and that the Board of Aldermen countered that they should have that authority as the spending was more like an appropriation, thus they alone possessed that authority. So you had the local executive arguing that the state legislature gave him the authority to spend the excess funds instead of the local legislative body, which is a fascinating twist to separation of powers. The court ended up ruling for the executive branch, who then directed the expenditure of the excess funds. In 1983, in an opinion from Andy's dad, Steve Beshear, who was the Attorney General at the time, Attorney General Beshear opined that only the executive branch could determine where to locate the offices of local executive branch officers, in this case in Flemingsburg, Kentucky. And I find this fascinating, as apparently a legislative body in Flemingsburg attempted to interfere with an inherently executive function that most people would deem as the most basic and intrinsic executive functions, which is where to locate the office of the employees who work for the executive. Another case in 1993, the U.S. District Court held that the Louisville Code of Ordinances, Section 153, which restricted the placement of political signs only 30 days prior to an election, was unconstitutional. However, it didn't invalidate the restriction that political signs must be removed within 7 days after the election. In another interesting case, in 1996, Metro government was permanently enjoined from enforcing portions of a mask ordinance in a suit that was brought by the Ku Klux Klan. Finally, in 2015, in a case that just happened 3 years ago, the Kentucky Supreme Court decided Kentucky Restaurant Association v. Louisville Metro. In this case, the court invalidated the Metro's minimum wage ordinance, stating that it conflicted with the overall statutory scheme in place that had been passed by the General Assembly. Thus, the higher minimum wage passed by our own Metro Council was struck down. Once again, an example of how the application of the separation of powers principles have an immense practical effect on our daily lives. In closing today, separation of powers principles are being utilized often by the various branches of our local government. The execution of these powers is necessary and embodies the necessary constitutional tension among these bodies of government. And as I leave today, I would be remiss if I didn't acknowledge my colleague Babs Elliott. I don't know if any of y'all know Babs. Babs has worked in city government for over 27 years, and she helped me with a lot of the research and the institutional knowledge on this speech. So thank you all. Have a wonderful day, and thank you for allowing me to speak on Law Day 2018.
Thanks, Jeff.